Hi guys, it's Kathy. I hope you're doing well. We made it to Thursday. Yes, we did. That means we only have one more day left in the week. I have this thing at work where hundreds of local businesses, they give out these little books to service workers around Lancaster, okay? Because they want the service workers to come to their business and see what their business is. That way, like when I'm talking to a customer, they can say, oh, well, what should we do in Lancaster today? I can say, oh, you can go here. I've been there. You can go here. I've been there. So we get 2 months to go to all these businesses. So my weekend is going to be busy. I'm going to try zip lining. I have a whole long list of things I'm going to try, and I'm probably going to get 2 of them done. But I'm excited because, I get to do all these things this week if I want to. I only have 2 months. So I have to get it done as fast as I can. It's free. Not all of it's free. Some of them just give a discount. Like there's this hotel near us that you get a premium room for 2 people for like $60 a night, and then you can use all their amenities. That's gonna be cool. But so I gotta plan. It's gonna take me 2 days just to plan the weekend. Don't worry, I'm not gonna miss any court. I won't miss any court. Be very careful. That's not the good way to do it. Don't hold on. When you go ziplining, Eileen, when you go ziplining, you go all in. Because if you're going to do it very carefully, well then you might as well, just go on a swings at a park somewhere. But, rock back and forth, kick your legs. Do it right. Put the fear of God in you. So by the time you get down, you're like, oh no, I am never doing that again. I wish we had skydiving, a local skydiving business that would be fun too. All right, we do have a bunch of wineries though. Ooh. I know. I can't wait. Maybe I'll snap some pictures and put them in Discord. Maybe. But first, I need to start this court case, or everybody will leave.
Matters. So, Tiffany Freeman versus Dominique DeCecco, and I have Dominique DeCecco versus Reasia Freeman. Then there's a third that I will get to. Okay, Tiffany Freeman. Good morning, Miss Freeman.
Good morning.
Okay. Now, Miss Freeman, your daughter is Breasia Freeman?
Yes, ma'am.
Okay. And Miss DeCecco, would you please turn on your camera?
Yes, hey, Your Honor.
There you are. Good morning. My boxes move around, so when the people come on, I'm like, okay, where are they now? Okay, and Ms. Sanders, I am going to ask that you swear in the parties.
Yes, ma'am. Raise your right hand, please.
I won't
Do
even
you
break a
solemnly
nail.
swear the evidence you shall give the court on the issue pending shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Yeah.
Okay,
Thank you.
so these are all a little related. I'm going to start with the case of Tiffany Freeman versus Dominique DeCecco. This is SPCB 2600526. All right. And then I'm going to circle back around to Dominique DeCecco versus Breasia Freeman. Now, I don't exactly know how all this fits together, but I guess I'm about to find out. Okay. And so the way we're going to proceed is this. Ms. Freeman, you will explain to me why it is that you want the petition for, why you filed the petition for stalking temporary protective order. And Ms. Freeman, you will have an opportunity, Ms. DeCecco, you'll have an opportunity to ask any questions if you want to clarify anything for the court. And then Ms. DeCecco, you will have an opportunity to testify in response to Ms. Freeman, and Ms. Freeman, you will then have an opportunity to ask questions as well. Ms. Breasia Freeman, is Ms. Breasia Freeman a witness in this case?
Yes, ma'am.
Okay. All right. And then we have a separate case there as well. All right. So you've all been sworn. Ms. Freeman, first of all, you're a resident of Chatham County?
Yes, ma'am.
And Ms. DeCecco, you are as well.
I'm a resident of both Chatham County and Effingham County because I do have a house in Chatham as well.
Where do you live?
I live in Effingham with my boyfriend. This is where I stay, but I have my own house in Chatham.
Okay. If you were filling out an application, whose address would you put down? Your official address?
Probably my home.
That is
in
what
Chatham
it
County.
really looks
Gotcha.
like.
Okay, that's all. I just wanted to be clear. Just want to clarify. So Ms. Freeman, tell me, start me off. Tell me why it is that you want a stalking protective order against Ms. DeCecco.
Yes, ma'am. And good morning, Your
I'll
Honor.
be
I just
very
wanted
careful.
to really
I
quick.
will.
We have several cases even pending in another court. Mr. Seiko noted in the other court to get something dismissed that she no longer resided in Chatham County. This was just in last month. And then even when she filled out her TPO against me, if you look at the top, it states Effingham County, and then she put her Savannah address, because I even filed several civil cases trying to have her served, and she stated she no longer lives there, so I couldn't serve her. So
well, she was served in these, and her information to the court today is that her legal address is in Chatham County. So, and really where she is served, it depends on whether or not this court can handle the matter. It appears that for this purpose, she's Chatham County. So I'm going to proceed. So, Ms. Freeman, tell me, there were some incidents particularly that you noted around March 2026 that you said involved stalking. Tell me about that. Tell me what prompted you to file this petition.
Okay, so the most recent, to be exact, was March 23rd, 2026.
Okay.
I was on my social media Facebook account, and I went live. I tagged a family member. Me and a family member had some issues, so me and a family member were going back and forth on social media. Mr. Seiko, inserted herself on the live, hearting and liking negative comments on me, stating I look like a man, I'm muscle build, I'll be in handcuffs, they'll put me in jail, I'll be in jail soon. It's several, and I insert some exhibits of her basically just on my live, obsessed. She reached out to my we were still married at the time, my husband, and screenshotted it and sent my daughter the screenshot of her sending my husband a friend request stating she's going to screw him. She sent my daughter the message stating I was a prostitute, which I have never sold my body a day in my life. I've been married with my ex-husband 25 years, married 18. So
if you're married, never mind.
She looked up my social media, sending my daughter screenshots of everything she was doing, stating that, she put my address on social media on her Instagram. And again, screenshotting my daughter, Breasia, sending her all of these things. You said I was a prostitute, then you posted my address, which put me in harm's way. I do stay in a very nice neighborhood. I live in Georgetown. I have never had any issues. I'm having issues now with being approached by couples asking me how much I charge to. She said I was a prostitute. I'm getting asked how much I charge. I'm getting I can go outside and
Any PR is good PR. Love any PR.
check the mailbox, and I'm getting people randomly driving by telling me I'm a prostitute and asking how much I charge. And I'm basically like, before I put cameras all around my house, I'm looking for a place to move. I feel so unsafe now. I check my cameras before I walk out my door.
Ms. Freeman, let me ask you this. So this happened March 23rd, 2026. When you were on social media with a family member.
Yes.
Okay. Has Mr. Checo been involved in any other lives since that date?
Not since that day, no ma'am.
Okay. And immediately after that date is when she reached out to your daughter with screenshots and with the disparaging comments.
No ma'am. So the March 23rd, 2026 was the social media contact.
Sure. Mm-hmm.
The first incident with the ex-husband, the prostitute, etc., that started happening September 1st, to be exact.
September 1st. We haven't gotten to September yet.
Oh.
That was in 2025?
Yes.
Okay, so we went backwards in time.
Okay. So the social media.
So the social media incident is March 2026.
Yes, correct.
Okay, just a few weeks ago.
Correct.
Okay, what is the relationship as you see it between you and Mr. Checo? Are y'all neighbors? Did you go to school? Did you work? What is it?
I didn't even know who she was until she started like commenting and stuff on my social media. I heard of her through my daughter. Her and my daughter were friends, and they had an issue, and she involved me. But
Okay,
before
so that's the how
many
you relate
leaders
to
fit
each
into a
other. I don't
CM?
mean that you have a relationship, but that's how that's how the dots are connected.
Yes.
And so your address was put on social media.
Correct.
And so when have you been contacted by other people?
Has
there been several times?
Several times.
Okay, so let me stop you there. So based on these incidents, you're asking that there be a 12-month protective order barring Mr. Checo to have any social media contact with you or to communicate about you on social media.
Correct.
Okay. And have those posts where your address was shown, are they still up?
I have not checked because when you put the order in, I think she filed something and you told me not to.
Okay.
So
This woman is
reached out
lying.
and I even reached out at.
I believe that she has been harassed by this other woman. I believe it 100%. But she's lying, which makes her sound completely unbelievable. If she would just stick to the truth, she would be fine.
One point prior before the court hearing, advising her that was illegal to post someone's address with ill intent. So it was kind of like a cease and desist type of thing I did.
Okay. All right. And I'm going to ask Mr. Checo, do you have any questions at this time for Ms. Freeman? This is not your opportunity to testify. You'll have a chance to tell me your side, okay? But do you have any questions for her at this time?
Yes. Could she provide the posts where her address was shown on my social media?
Is that in the exhibits?
Yes, ma'am. It is Exhibit I.
Let's see. Maybe they weren't put in under this case. Okay.
I think, Granny, it goes both ways on that one.
Okay. Let's see what I have here. I see.
I didn't post the address of that Nigerian scammer we had yesterday. Hi,
And that is
Lisa.
her Instagram name where she posted it. And then I also took a screenshot of what's, on Google just to show you what she posted.
I would like to validate that post, please.
Okay. All right. Let's see. You got a lot of stuff in here.
And ensure that it's public, not a private message.
Lisi's never mean to the boys, though. I am. I'm mean to the boys.
Well, can you tell me?
I am.
Did you post it?
No, I didn't, Your Honor. What I did do, well, it's not my turn to testify.
Yeah, it's not. Okay. So you have a lot of exhibits in here, but you're saying it's exhibit 5. I'm trying to avoid going through all of the exhibits.
Okay, it's I as in India. I'm sorry. Yeah, exhibit I, yes, ma'am.
Oh. Miss Cuffy, could you take a look? I am looking under the case.
Really, I have a better chance of crashing my car. Actually, I have a very good chance of crashing my car. I can't see, but that's besides the point.
00466. Because I think all the exhibits were posted under this one and not the case that I'm on right now, which is 00526.
And Ms. Friedman, are you saying that you have it's the Facebook post that you're trying to show?
It's her Instagram. What's her Instagram? It's verified. You can see her picture, her Instagram.
No, I don't need an explanation. I just need to know what you're trying to show.
I think if I don't touch it and I keep my hands up the whole time, I have a better chance of not breaking it and falling down and dying. So just hands up the whole time.
Hold on one second, Judge.
Sure thing. Okay. So what I have here is a number of exhibits. Oh, here we go. Composite of exhibits. Okay.
Ms. Freeman, are these the exhibits that you sent on yesterday? Or the
Michael, I have something for you later. Michael, you're going to like it. When she says she has a lot of exhibits, I believe, but I'm not sure. I think we're going to find out. There's hundreds. These ladies submitted hundreds of exhibits.
this morning?
No, I sent them Sunday because I see I emailed them to the email address on the thing stating if you have any exhibits to email within 48 hours. So that was Sunday.
Judge, it's possible that these are some of the exhibits because there were so many that the clerk's office is still trying to upload them. I mean, there was over 100 exhibits sent.
Okay. They're not uploaded
yet. There are a bunch of
yet.
exhibits here, and I'm just trying to get to the one you are referencing.
I apologize. I just wanted to make sure I submitted all my evidence.
I understand.
And I would also just like to validate those posts that I made publicly about her calling her a prostitute. I would like to see those.
Okay. So, from your side, Miss DeCecco, do you only have up the Odyssey? Miss Sanders, can you help me understand?
Yes,
There are exhibits that have been placed in. So do the parties have access to see those exhibits as well?
as far as Odyssey goes, give me 1 second and I can get that answer.
No, I guess that what I'm asking is I can pull them up.
Michael,
are they
you
able
home
to
yet?
pull these up also, or do I have to do some kind of screen share?
Oh, that would be some type of screen share, I believe.
Judge Love, it's 2026. Do you really not know how to share exhibits on Zoom yet? It's been 6 years.
I don't think they have access to pull them up.
And I do want to clarify a couple of things. Ms. Freeman stated.
Micah,
Not
that
yet.
sucks.
Not yet.
That sucks.
You have your opportunity. Okay. So, while we're sorting out whether
Judge,
or not I can,
sorry to interrupt.
no, it's fine.
Found Exhibit I. I can share my screen. It doesn't look like an Instagram post, but I can show what's labeled as Exhibit I by Ms. Freeman.
Okay.
Okay, hold on one second.
So, your question, Mr. Checo, is to Ms. Freeman is about your posting of the address. And so,
Yes.
so here it is.
That is not a public Instagram post, Your Honor. That is a private message that I sent to Breasia Freeman, the daughter, not publicly on Instagram. That is a DM and a
Okay.
private.
Ask your next question.
And then my next question is about the post that I made.
No. Ask her a question.
Okay. You stated, I wrote your daughter calling you a prostitute, and then men started driving by your house. So can you clarify that? Why would men be driving by your house if I wrote your daughter calling you a prostitute?
If you're telling people I'm a prostitute,
I'm gonna stop. That's really not a proper question. What other question do you want to ask her?
Okay, I guess what I'm getting at is that I never publicly posted her being a prostitute. That was a private conversation between the daughter and I on the initial fallout because the daughter talked about my mom.
And it's 100% not illegal to tell someone that their mother's a prostitute. That is not against any law. It's just not.
First, who was deceased.
Okay.
August 1st.
What other questions do you have for Ms. Freeman? You'll have an opportunity to tell me your side.
I mean, that was the question. I was just clarifying. She stated I wrote her daughter.
No, ma'am. So anyway, so you've asked her about the address, and you've asked her about a question that really she can't answer. Why would people be coming to her house or contacting her about sexual relations? Okay, so I'm going to turn to you, Ms. DeCecco. I'm going to come back to those exhibits, but Ms. DeCecco, what do you want the court to know?
Okay, I have never ever contacted Mrs. Freeman before. That statement, calling her a hoe, was because during the initial fallout between the daughter and I, the daughter kept making comments about my mom, who's deceased, saying that's why your mom died and all this bad stuff about my mom, who she never met. And I acted on emotion and said, you know, my mom might have passed away, but she was a doctor, a very honorable woman, and your mom is a known hoe. And that's just things that I was told by various people in Savannah. And that was a statement I made in a private message.
Don't tell the court anything that somebody else said. That is hearsay, so I'm not going to consider that. What else do you want me to know? So far you've told me that you and Ms. Freeman's daughter got into it because Ms. Freeman's daughter was saying some things about your mom that you didn't like. What else?
It goes beyond that, but she was posting things obsessively about me for days on the internet. And her and
Who was?
the daughter, well, both, but in this instance, the daughter at this time, August 31st to September 2nd, the daughter was at that time. And so I responded.
So that's the case you're getting into, the case you have against Ms. Breasia Freeman, right?
My whole point is, that I never posted anything about the mom publicly and I never posted their address.
What else would you like to tell the court that relates to Tiffany Freeman?
Okay, so after that initial fallout on September 2nd, I never had any other, I totally disengaged and there has been no other contact by me at all.
To who?
Either one of the parties.
Okay, I'm asking you, I'm trying to keep the lines clean. Yes. I'm asking about Tiffany Freeman. What was your last social media contact whatsoever to Tiffany Freeman?
I have never contacted Tiffany Freeman
That's not my
before.
question. Okay, so you're saying you've never contacted Tiffany Freeman?
No, that live that she's referring to she was talking about me and addressing me by full name, Dominique DeChico, and saying that I eat ass and do other things, talking about personal and private affairs that I
You're
engaged in.
you're saying that Tiffany Freeman was saying those things about you on a live?
Yes, and I've entered all those exhibits. And that's why I was on the live hearting the other party's comment because they were defending me.
Okay. And anything else you want me to know about about Tiffany Freeman?
Just that I have never had any contact with her. And after the fallout between Breasia and I, August 31st.
I'm not asking you about that.
Yeah, I've never.
So
had any-
other than on Tiffany Freeman's live, you're saying you've had no further contact with Tiffany Freeman?
Correct. And I did not comment on that live. All I did was comment that other people made defending me.
Those are comments.
Yes, but I did not
So
respond.
those are comments.
A like is not a
Let's see.
comment.
And
Judge.
Ms. Freeman, you may call your next witness.
Breasia Freeman.
All right, Ms. Freeman, please turn on your camera, and you have.
And this is the one I think
and you are
started it all,
Breasia Freeman,
right?
And you're the daughter of Ms. Freeman.
Yes, ma'am.
Okay, and I understand that you and Mr. Checo have been friends before?
Yes, ma'am.
Okay, is that how you would describe the relationship? How long have you known each other?
Maybe 3 years.
Okay, and is that through school, through work?
Work.
Okay, and where did y'all work?
In a strip club together.
Okay. All right. So, Miss Freeman, you may ask questions of Breasia.
Yes, ma'am. Breasia, did DeCico Dominique? I'm not sure what you want me to address her up. I'm sorry.
DeCheco. Miss
Okay.
DeCheco.
Miss DeCheco. I'm sorry, Breasia, did Miss Checo initiate the communication with you involving me?
Yes.
Before this, had I even known anything about Miss DeCheco?
No. I mean, you knew we were friends, but that was it. Like.
Okay. Did Miss Checo send you screenshots showing that she was looking up myself and your dad and other family members via social media?
Yes.
Did Miss DeCheco send you a text message stating and alleging that I was a prostitute?
Yes.
Can you verify the Instagram post with the address and Miss DeCheco sending our address to other people?
Yes.
I've been
And
told the
did you
same
upload
thing.
that?
I have it, but I don't know if she have it, but I have it in my evidence of her sending the address to random men. Yeah.
Okay. So we'll come back around to that.
Okay.
So
Did you want me to continue? I'm sorry, Yana.
I'm sorry. Let me take a second to take a look. You put all of these. Okay, who is OCCICED? That's DeCheco?
That is
Yes.
her.
Okay.
Each one of those books behind her costs like $150.
So I'm just looking at the.
Okay.
Oh man, there's some things here. Ms. Freeman, you did a whole dump.
Yeah, I wanted to make sure I stayed up for days and weeks. I'm sorry.
I see that.
If I can, Your Honor, point out the actual date we were talking about, 3/23/2026, that Mr. Checo said I was speaking on her. It's a screenshot, exhibit Q and R. I tagged my cousin. I was speaking directly to my cousin, and you'll see where Checo was like literally hearting everything, the prostitute, I would like
now, okay.
Mhm.
But you were having an argument with someone,
a family member.
a family member, and it was public.
I mean,
Yes.
most women will do that for $20.
And then
friend.
when it's public in that way, other people can see it.
Correct.
And people get hurt
Correct.
and comment.
Correct. But she's stating I stalked her page when she was on my page.
Note for the future.
Okay.
Don't beef in public if you don't want other people to comment.
I agree.
All right?
Yes, ma'am.
I'm going to have to say that. Okay. Let's see. Lord have mercy. No. Let me just see.
All right. I think you should test my theory, Brad. Just go to 10 random women today with a $20 bill in your hand and just see. Test. This is for science, right?
So I see y'all been to mad court.
Yes. We're still in court.
Okay. I'm going to step away for just a moment, okay? Y'all stand by.
Okay.
I don't remember any pauses. I can't watch your court case because you guys don't stream. All right, I'm going to try to fast forward it. I don't remember a pause in this. I'm sorry. Look,
all right, ladies.
Never mind. I'm not going to move
I am
it.
back. Court is back in session. Please turn on your cameras. All right, I was trying to sort this stuff out. Okay. So, Ms. Freeman, I will say that there is a particular way that exhibits are to be entered so that we can all look at the same thing at the same time. You got a lot of stuff in here. It is not easy to pull it all up, but I want to move on with testimony, okay?
I bet you almost everybody in this chat has had the encyclopedias because we're all that old, except maybe Bren. All the rest of us are old. Cher, I don't know how old you are, so maybe not Cher, all right? But we, I bet you she did read them because that's what we read. That's how we did all of our school reports. We did the encyclopedias we're upstairs in the closet in the other room.
Yes, ma'am.
I'm going to turn to Mr. Checo. Mr. Checo, what questions do you have of Breasia Freeman as it relates to this case with her mom?
Yes, the foundation of the image shown of the address. It had no context. It didn't say a name, didn't say who it was sent to, doesn't specify. So I would like to...
How many of us tried selling encyclopedias door to door maybe once in their life? Anybody? I did not. I was this close, though, to becoming I tried everything.
I would like to discuss the foundation of that exhibit.
Do you have any questions for Breasia Freeman?
No.
Okay. Well, go ahead and tell me what you want to say.
Yes, I would just like to discuss the foundation of the image shown. That image did not show a phone number. It didn't say, this is Tiffany Freeman's phone number, go harass her. It didn't have any context. That was a private message, not a public message. So I would like to confirm what's the foundation behind that image? Where did the image come from? Who is it sent to? And why is it considered harassment?
Okay, I have a question. Why did you take a picture of the house at all?
Okay. So I didn't take a picture of the house.
Okay.
That was sent to me
All right.
because we were going back and forth. The initial fallout between August 31st and September 2nd, the fallout lasted 2 days. She was saying a bunch of things about me online. She said that she has her own place.
Okay.
That's where it came from. She said she had her own place.
Okay.
And then somebody said, no, she doesn't. This is
I
where
don't
it's-
want to hear about what some nameless person said.
Well, it was
Tell
my
me,
witness.
tell-
to that.
don't tell me what somebody else said.
Okay.
Okay.
So I sent it to her to confirm you live with your mom right here. You don't have your own place. It was just to basically discredit her, to say that she was lying,
All right. Okay.
but was
All right.
not intended to harass.
Thank you. Anything else you want to say, Mr. Checo, before we move on?
All right, guys. Did anybody, is there illegal harassment here? Is there going to be a protective order because there's been harassment? I'm going to say no, because here's why I'm going to say no. Because what she sent to the little girl in private messages about the mom, that's not doxing her. I don't see anything she did publicly. The mom had a live stream. So, if someone comes into my chat right now and starts, loving, insulting comments and things like that, just remove them from chat. There's nothing legally wrong about that. They can call me fat, ugly, stupid, whatever. There's nothing. They can call me a hoe. Or my mom is a hoe. They can. There's nothing. I don't know. But unless something happened in those hundreds of exhibits that we don't know about, I'm going with no. But who knows? Maybe the judge will just say, I think you all need to leave each other alone. I'm going to put the protective order on.
No, again, that exhibit was from August 31st. That's all I have to say.
Okay, thank you. I'm going to move on then to Dominique DeCecco versus Breasia Freeman, SPCV 2600467ST. Both you ladies have been sworn already. And Miss Breasia Freeman, is your mom a witness in your case? Unmute yourself.
Yes, ma'am.
Okay. All right. So, Ms. Breasia Freeman, I'm going to call you your whole name so we'll know I'm not calling you.
Okay, now we might have. Because these are the ones that had beef to begin with. So we might have it here. I don't know.
Getting you confused with your mom, okay?
Okay.
So, Breasia Freeman, I'm sorry. Wait a minute. This is DeCecco versus Breasia Freeman. Okay, Mr. Checo. All right, now we're going to get into, let me turn to you, because actually you're the petitioner against Breasia Freeman. All right, so tell me why it is that you want to talk.
Just one. I'm not gonna pause again, but I'm gonna do one. I want to join Kelly. Your mama's so fat when she sits around the house. She sits around the house. No more. I'm done.
On protective order against Breasia Freeman.
Okay, so I'm going to kind of go in chronological order of events because it is a lot. So basically, again, we were friends.
Okay, go ahead.
We were friends. We had been out socially on August 31st, night of.
August 31st, 2025.
Yes.
Okay.
At the end of the night, we had a disagreement. Being that we've had a small disagreement in the past, we remained friends. She left. And she was a little belligerent. It was 4:00 in the morning and she didn't have car insurance. So I did text her and I said, hey, be safe driving home with no car insurance. I put a heart on there. And that was genuine because one, she didn't have car insurance. It was 4:00 in the morning and she was belligerent.
Okay. All right.
So anyway, after that, she responds, go get a mom. That's why your mom died. And then took to Instagram, obsessively posting about me, very defamatory, degrading things, saying I had genital herpes, which is not true. I have negative test results, and amongst other things. After that, I acted on emotion and I direct messaged her.
It's not true. I've been tested.
And I did not make any threats, but I did say insulting things. That went on for And then also all of those exhibits are in evidence where she did make threats and also stated that she posted a picture of my vagina on Instagram. All of those exhibits are in from the whole initial fallout. Then she's posted about me for 2 days straight. All of those are in evidence, saying very untrue things. Anyway, I did act on emotion. We went back and forth. That's when I said thing about her mom, because she talked about my mom, who's deceased. After that, I received about 20, 30 followers coming off of all of Brieja's posts. I did receive a bunch of followers. So when all these 20, 30 followers followed me, unwanted attention, I was humiliated. They were all coming off of her page from her posting things about me, very degrading, untrue things. So out of humiliation and embarrassment, I did contact one or two of them, and I sent a screenshot where Brieja lied about having her own place. That was to discredit her and say, you can't believe anything she's saying. She'll lie about anything. And that was to
Did you post that?
I didn't post anything. I sent no. I didn't post anything. So
how would you discredit Miss Brieja Freeman with where she lived if you didn't make that public?
right. So as I stated, when she
No, answer that for me.
because I got 20, 30 followers and I
That's a great point, Sarah.
inboxed it directly to one person who messaged me.
You shared her information.
I shared a screenshot of our text message where she said she had her own place in her own car. And I responded, no, you don't. You live at one road with your mom. Later, I heard
You sent those test results to who and how?
My screen just stopped. My stream just stopped for a second. I'm just making sure YouTube has got their stuff in order before I press play. Okay. I think we're good. I don't know what happened, but my live stream just stopped for a second.
to like one of the people who followed me, because I had like 30 people follow me when she was making all these posts about me, because she was putting my picture and my username and everything. So it was drawing me a lot of attention, negative attention. So I didn't want people to believe that I had genital herpes. So I sent my negative test results and a screenshot that said, Brieja said, I have my own place in my own car. And I said, no, you don't. You live with your mom on the road. That was not intent to harass. It was intent to discredit her. But later, I didn't even realize that her address was in it until later she brought it to my attention and said I was sending her address to random men. And all of that is in the evidence as well, where I explained that I did not send her address to random men. Those people came to me off of her page because of her post, and that I was doing it to discredit her. But I didn't even acknowledge at that time that the address was in there. It was just about the context of the text where she lied. That's all was the point of it. And I only sent it to one person in a private message. It was never publicly posted. Same thing with the mom. I never posted anything about the mom being a prostitute. That's why it would be impossible, in no way for men to be driving by her house or saying anything to her for something that I posted, because I never posted anything publicly. That was something I stated to the daughter in a private
Yeah, I think the mom lied about that. I just do.
message. So unless the daughter shared the post or told everybody her mom's a prostitute, there would be no reason why guys would be coming up to her asking how much due to me posting anything. I never posted anything publicly. So that was all the initial fallout. After the 2 days her and I went back and forth, I totally disengaged. That was September 2nd. I made no further contact, and I never made any direct threats, or any threats at all, actually. No threats at all. And I acted on emotion when I responded to her privately, not publicly. I did not ever make any posts targeting them directly at all. I never made a post stating their names or anything like that. So moving forward, that was September 2nd. I dropped it. Situation was over. Then, on September 2nd, all the way through November 9th, there had been a fake page under the name Monica Smith. At first, I didn't know who the fake page was. It was monitoring all of my posts and basically cyber stalking me. After, I would say, October 5th, Brieja revealed herself that it was her fake page because she was commenting bizarre things on my posts, and she was also contacting my followers directly, saying very degrading, untrue things about me to my TikTok followers, who then sent me screenshots, which I also entered all those exhibits into evidence. And then once she revealed it herself to me, she also sent me a private message off the fake page. Then she went ahead and changed the name and the picture to her name. She uploaded a picture, so it said Monica Smith, and then she changed it to her name because she knew that I knew it was her on the fake page. So she had been cyber stalking me and making fake pages to contact myself and also my followers to harass, intimidate, and say degrading things. So that continued from September 2nd to October 5th or 6th, actually, specifically. Then, and all of that is in evidence too. So she was making unwanted comments. She was messaging my followers, degrading things, saying things that aren't true, like that I had threesomes with old white men for weed money. I've never had sex with an old white man. So that is defamatory.
Okay. Now,
And so-
one thing that is clear to me is there's a lot of information among the three of you, one way or the other. Ms. Breasia Freeman, are you the only one that didn't file an action?
I actually did.
You here with me?
Yes, I did.
Okay, I have one with Tiffany Freeman against Dominique DeCecco. That's a new one. And then I have Dominique DeCecco against Tiffany Freeman. And I have Dominique DeCecco against Breasia Freeman. Okay.
I did file one, but I don't know what happened to it.
It's okay.
Okay.
The bottom line.
I can see the case number.
It's okay.
Okay.
It's okay. So what is the case number before I stop you?
Okay, let me go back.
SPCB.
I'm sorry, I'm logging back in now. You said it was okay. I backed out. Sorry.
I have it, Judge. It's SPCV 26-00591 ST.
Okay, that's separate from the ones I'm looking at right now.
Yes, ma'am. It looks like Breasia Freeman filed that against Dominique DeCecco on April 16th.
Oh, that's just been filed.
Yes, ma'am.
I would like to mention there has been a lot of cross-filing games.
Miss DeCecco, I can see that. There are a lot of cross complaints. There's a lot of allegations, accusations, exhibits that none of this is good or flattering to anybody. Okay.
I'm glad to say something.
The stalking 12-month protective orders I have before me are at the point where I can order 12-month protective orders are against Ms. Freeman, Tiffany Freeman, and Breasia Freeman from Dominique DeCecco. Ms. Breasia Freeman and Ms. Tiffany Freeman's are newer, and they're not at the point of a 12-month protective.
It sucks it didn't show up on the screen, Sarah, but thank you for the sunshine. I appreciate it. Thank you.
Order. I think everybody has a little dirt on their hands. Everybody's been playing into stuff that they shouldn't. All y'all need to stop now.
Yeah.
So
I'm over it.
Y'all need to be over it.
I'm over it.
I'm just learning about it and I'm over it. So what I'm gonna do is this.
I want to see the exhibits.
12-month protective orders do impact you in a way that is more significant that you probably want any of you to have to deal with, because they actually get reported to the state and all that. I'm going to dismiss the TPOs, but I am going to impose mutual restraining orders against everybody. All right? Mr. Checo, have no contact, direct or indirect, with the Freemans. The Freemans, you're not to have any contact with Mr. Checo, direct or indirect. And that would include social media. Everybody. Pardon me?
I didn't get to say something. Can I just say something real quick?
Go ahead.
I didn't get to say anything yet.
Go ahead.
Okay. I've been over this situation. Like, we done went to court. She keep filing stuff. For one, she started this whole mess. She keep filing stuff. It's been 8 months. I'm over it. I want her to leave me alone. She's staying in Effingham. I'll never see her again. I'm done. She need to be done.
Do y'all work together anymore?
No, she's staying in Effingham. Even when we were friends, we never crossed paths.
If she lived down the street, I'm just going to say, I know you don't. I know you don't. Nobody have contact with the other. And I'm also going to order that if you have any posts out there, take those down. Go back through your social media, take any mess down that disparages the other. Okay. Ms. DeCecco, what are your thoughts?
My thoughts are that beyond the initial disagreement,
For the record, you can say whatever you want to say about my mom. It's fine. I'm fine.
I haven't made any contact or did posted anything.
Okay, then good. Then good. They don't,
Since you-
no, I don't need to hear anything else because it's all around the same thing. Everybody is ordered not to have any contact, direct or indirect, with the other, period. I'll issue those orders today.
Okay.
Thank you.
Thank
The
you.
violation,
We're in recess.
She cut the feed there. They were still talking, but she cut the feed. I got one from Maiko. Something in here. Something in here. For a quick second. We'll remind everybody of Maiko.
Just checking with you.
Whom I love. Love you, Maiko.
Why is Mr. Downport SB9? Got it. Good morning, sir. Can you tell me your name?
No, Maiko, that doesn't remind us of you.
Mr. Downport, you have been charged with possession of a controlled substance, which is a state jail felony offense. It carries a range of punishment of 6 months up to 2 years in the state jail facility and a fine not to exceed $10,000. And you've also been charged
No, this isn't court one. This is the 184th. I know.
with unauthorized use of a motor vehicle, which is also a state jail felony. I'm going to hear probable cause from the prosecutor. Probable cause is not a trial or a finding of guilt. It just gives the court more information about the allegations. Same transaction, Ms. Coronado? What's the PC?
So on April 12th, 2026, officers observed the stolen vehicle in Harris County, Texas, and conducted a traffic stop. Officers detained the defendant and looked at the report from the night the vehicle was stolen. CW stated that he was gambling outside of Popeyes and he was approached by a black male wearing a medical boot and was told by the defendant that he owed him money. CW attempted to leave but was stopped when the defendant picked the firearm and stole the vehicle. Officers spoke with the CW and informed him that his stolen vehicle was recovered. CW never gave anyone permission to drive his vehicle. The defendant was also wearing a medical boot at the time of the detention. Officers completed a search of the stolen motor vehicle and observed several forms of paraphernalia in plain view. Officer observed scrap pipes, marijuana pipes, and a usable amount of crack contained inside the stolen vehicle. The weight of the crack cocaine was 0.03 grams.
Thank you for being multiple level for 21 months. Thank you, Terry.
And Star's criminal history is an ABROC from 1997, 10 years CDC, PCS 1997, 2 years CDC, PCS 1999, 2 years CDC, Mandel 2000, 3 years CDC, PCS.
So yeah, I mean, he has all of these priors, and he got 5 years in prison, 2 years in prison, 3 years in prison, but the next crime is like 1 year after, 1 year later, 1 year later. If maybe he would have done his time, it's fine.
2005,
Harris
5
County,
years
Texas.
CDC, evading 10 days county jail, POM 10 days county jail, POM 10 days county jail, and then she does have an out-of-state criminal history, aggravated promotion of prostitution from Victoria, 5 years CDC.
Are y'all going to be filing aggravated robbery charges? Are y'all still investigating that?
I believe we're still investigating that, Judge.
Okay, can you tell me about Mr. Dalcourt?
Yes, Judge. Mr. Dalcourt is from Houston, Texas. He has 2 children and 1 minor nephew that he is essentially financially responsible for. He does own a trucking company. The income, from my understanding, it fluctuates every month based on the need and the jobs he can actually get. And Your Honor, he's not opposed to any conditions that the court may impose as far as remaining in Harris County or contiguous county.
Okay.
You can tell it's Harris County Courthouse because that guy in the back, that dapper young man back there in the, I don't know what color that is. If I say a color, everybody's going to say no. It's light salmon, light orange suit. That's Michael. Yep. Hi, Michael. We miss you.
Looks like the state is requesting a $40,000 bond on the UUMB and a $40,000 bond on the PCS. Is there an amount you're asking me to consider?
Yes, Judge, just due to the amount in the PCS that was recovered, we would be asking for a PR bond on that case, Your Honor, or if the court is not inclined for a PR bond on that case, we would ask for $1,000. For the UUMB, Your Honor, we're asking for also $5,000 on that case.
Okay. Sir, I'm setting both of your bonds at $25,000. I'm ordering that you appear in court, commit no new law violations, have no contact with the complaining witness. What's the complaining witness's name?
Jeffrey Harper.
Have no contact with Mr.
Michael,
Harper.
thank you.
And you said they were outside of a Popeyes or something? Okay, refrain from going to that location. I also want you to start outpatient treatment. You will have to submit to random drug and alcohol testing. No drugs, alcohol, or firearms. And I do want you to have a GPS monitoring device. Do you understand your conditions, Mr. Dalcour? Okay. You will sign them with the gentleman behind you in the jacket as soon as he's ready. Thanks. I'm gonna start with Mr. How do I say your first name? Michael.
Thank
Okay.
you so much. Michael.
Okay, good morning, Mr. Garcia.
Michael.
You have been charged with assault family member with a previous conviction. Sir, this offense carries a range of punishment of 2 to 10 years and a fine not to exceed $10,000. The state was not abandoning the enhancement paragraph from 2021. No. So it's now a second degree.
Judge, I'm not sure. I didn't do the paper.
It doesn't say it.
Oh, yes.
Should I see it?
Oh, Micah.
No.
Okay. And it is true that you are the same Micah Garcia who was convicted of continuous violence in 2021 in the 182nd District Court?
Yes, ma'am.
How do you plead to this third-degree felony offense with the enhancement paragraph, guilty or not guilty?
Guilty.
Are you pleading guilty because you are guilty and for no other reason, sir?
Yes, ma'am.
Has anyone promised you anything other than this plea bargain agreement to cause you to plead guilty?
No, I'm not.
You're pleading guilty freely and voluntarily.
Yes, ma'am.
Has your lawyer gone over all of this plea paperwork with you?
Yes, ma'am.
And he has answered all of your questions?
Yes, ma'am.
Do you understand that by pleading guilty, you are giving up your right to a jury trial?
Yes, ma'am.
Do you also understand you're giving up your right to appeal?
Yes, ma'am.
And you still wish to move forward, sir?
Yes, ma'am.
You believe your client is competent?
I no objection.
Stay off for stage.
No objection.
Are you an American citizen, sir?
Yes, ma'am.
I will accept your plea of guilty and sentence you to 2 years in the institutional division of the Texas Department of Corrections and give you credit for the time you served. Is this other case being dismissed?
Yes.
Okay. Now let's move on to Mr. Gutierrez. This is a true third.
Yes, Judge.
It was a BAC.
Yes, only one, please.
Okay. Mr. Gutierrez, you understand you'll have to go to inpatient treatment at the substance abuse facility.
Yes, ma'am.
Okay. Was there an accident or anything? Any restitution?
No.
No, Judge.
You also understand you cannot smoke marijuana while you're on probation. I know this assessment that you completed with the probation department, you call yourself a chronic smoker, so you cannot smoke marijuana while you're on probation. You understand that, sir? But that's why we're placing you in treatment, so you can get all the tools you need so that you don't resort to alcohol and controlled substances. Do you have your high school diploma or GED?
Yes, ma'am.
Okay. And do you have any employment lined up, or will you need help obtaining employment? It says unemployed while still being employed. That doesn't make any sense.
I
Okay,
didn't know, honest, until I get out.
okay. Well, you're gonna be participating in a program called Work Faith, so we can help you obtain employment. Okay, Mr. Gutierrez, you have been charged with DWI, third or more. This offense is a third-degree felony, which means it carries a range of punishment of 2 to 10 years and a fine not to exceed $10,000. How do you plead to this third-degree felony? Are you pleading guilty because you are guilty and for no other reason?
Yes, ma'am.
Has anyone
Happy
promised you
birthday,
anything
Sarah.
other than this plea bargain agreement to cause you to plead guilty? You're pleading guilty freely and voluntarily.
Yes, ma'am.
And your lawyer has gone over all of this plea paperwork with you,
Yes,
answered all of your questions.
yes, ma'am.
You understand that by pleading guilty, you're giving up your right to a jury trial.
Yes, ma'am.
You also understand you're giving up your right to appeal.
Yes,
And you still wish to move forward, sir? You believe your client is competent?
ma'am. I do, Judge.
Wait, Officer, next one.
No objection.
Are you an American citizen, sir?
Yes, ma'am.
I will accept your plea of guilty, sentence you to 10 years in the institutional division of the Texas Department of Corrections, and probate that sentence for 5 years. That means you're going to be on a 5-year probation. While you're on this probation, you're going to be ordered to complete certain conditions for you to be successful. Your first condition is that you complete SATF. Okay, it's the substance abuse treatment facility. You're also going to be placed on the DWI caseload, which means that you will have to complete 2 victim impact panels. I also want you to complete outpatient treatment after you are released from SATF. And you're going to have a SCRAM device, sir. That's an alcohol monitoring device. No drugs or alcohol. Best of luck to you, Mr. Gutierrez.
Thank you.
You're welcome.
No, there's 2 buildings. When you go, you see there's the criminal, and then sort of like beside it and back a little bit is the civil building in Houston. They're real tall. I mean, there's so many floors. So Judge Fleischer, he's on the 9th floor, right? He's on the 9th floor. This is probably just the 4th floor, or the 8th floor, or whatever.
Thank you, Judge.
Thank you. Yes, sir. Thank you. Okay, Miss Evans. Okay. I just want to read this to make sure she's. So where exactly is she going?
It's going to be in temporary housing for the immediate future.
Uh-huh.
I'm going to get the
Monica, thanks for the
physical
cheer.
address
Thank you.
from Mr. Valentine. He works with an organization called Healthcare for the Homeless. And so in the facilities that they manage, they allow people to have access to psychiatrists and psychologists. There's medication monitoring, as well as access to education and job opportunities as well.
Oh, that's good. So are they going to come pick her up?
They are coming to pick her up. The order states she's only to be released. to
Okay.
Mr. Valentine.
Okay, you understand that, Miss Evans? And they'll have all her medication there? Okay. Okay. So was she on her medication when all of this happened?
No.
No, okay. So you understand how important it is for you to be on your medication, Miss Evans? Okay. Okay, and the family's position is that they want no contact, or is it no threatening, harassing, or assaultive? Because they usually come to court, don't they?
Yeah. Dr. Lee?
Are they here? What is their position? Come on up, sir.
He walks like I do after a shift. Trying to get to my car.
Okay, good morning. Good morning, sir. Good morning, ma'am. What's y'all's relationship to Miss Evans? Her sister? Okay. Because the stuff, you're the complaining witness on one of the cases, right? Okay. Is it the father? Both of them are. Okay. So are y'all going to be in contact with Miss Evans? No, you don't want any contact? Oh, okay. Okay. So their position is that they want no contact. So while you're on this supervision, just focus on maintaining your sobriety, taking your medication, What is she also going to be ordered to do? And you have to complete an anger management course, Ms. Evans, okay? Okay, there's going to be a no contact order
That's so
since y'all's
sweet.
position is that you don't want any contact, okay? Thank you all. Okay, you understand what you have to do to be successful?
Yes.
Okay. Ms. Evans, you've been charged with aggravated assault against a family member. This offense is a second-degree felony, which means it carries a range of punishment of 2 to 20 years and a fine not to exceed $10,000. Ms. Evans, how do you plead to this offense? Guilty? Are you pleading guilty because you are guilty and for no other reason?
Yes.
Has anyone promised you anything other than this plea bargain agreement to cause you to plead guilty?
No.
Are you pleading guilty freely and voluntarily?
Yes.
And has Miss St. Julian gone over all this plea paperwork with you?
Yes, ma'am.
She's answered all of your questions?
Yes, ma'am.
You understand that by pleading guilty, you're giving up your right to a jury trial.
Yes, ma'am.
You also understand you're giving up your right to appeal.
Yes, ma'am.
And you still wish to move forward, Miss Evans? You believe your client is competent?
She is, Your Honor.
Signal for 6-1.
No objections.
Are you an American citizen, Miss Evans?
Yes, ma'am.
I will accept your plea of guilty. What I'm going to do is defer a finding of guilt. You understand that means you're going to be placed on a 2-year deferred adjudication. Just think of it as community supervision probation, okay? In order for you to be successful, you do have to complete certain conditions. I want her to stay at that facility. What's the name of it?
Healthcare for the homeless.
Okay. I want you to, you're going to be ordered to stay at healthcare for the homeless, okay? I'm also going to be ordering that you complete a course called Thinking for a Change as well as anger management. And you need to comply with all of your medication treatment. And unless your family says they want to have contact with you, I'm going to keep it at no contact. And then if they tell your probation officer or the prosecutors that they want contact, we'll amend the conditions, okay? It is no contact for right now, okay? Best of luck to you, Miss Evans. You're going to do well, okay? You're welcome.
Thank you so much.
This next guy.
Joe, is Tony going to be able to come? Good morning.
I just give my
How are you?
question.
Yes, ma'am.
Judge, I'm just checking in. We have trial set tomorrow for Mr. Randy Mims.
Oh, yeah.
Just wanted to check in what time you would like to do your school.
Are y'all, I'm glad you stopped by. Where's the prosecutor on this case? Who is
They
it?
did email for the prosecutors. Yes, I did, I did message him. I haven't gotten a response to that one. But I'll continue to try and reach him.
Is it a guilt innocence issue
Yes,
or
Judge.
punishment issue? Okay.
Guilt innocence.
Have they evaluated the case?
They have, from my understanding, yes, Judge, and I know they have the 30-year offer, so we are,
Is he enhanced? Is that why the offer's 30 years?
yes. I know they have
Okay.
history there, Judge.
Okay. We have a press set manslaughter on Monday, the 20th. And so I will, once the prosecutor gets here, let's talk about some other dates.
Okay, Judge.
If the case does not resolve.
Okay. I'll
so,
send down then, and
okay,
I'll wait for the
for Wednesday.
prosecutor.
Okay, thank you.
Congratulations.
Good morning, Mr. Vela. Yes. Good, how are you doing?
I've got, 40 years got I on the documents in custody. Yeah, those are just
Okay, there was a lot of names. What was the last? Oh, okay, I see it. Uh-huh.
Gotcha. No,
Uh-huh.
yes, ma'am. I think that,
Pretrial.
your
PC.
PC
Uh-huh.
condition is.
What's the PC?
So the report C is Luis Reyes, witnesses Diego Moria, and CW is Demetrios Petropoulos. And on March 21st of 2026, officer was dispatched to 2520 Montrose Boulevard in Harris County, Texas. CW one that Demetrios is the owner of Nico Nico's restaurant. CW1 stated that an unknown Hispanic male damaged 8 windows with rocks, costing the company $8,000 in damage. CW1 has a video of the incident. Witness 1 stated that he saw the defendant charging his phone on Nico's property. Witness 1 confronted the defendant and asked him to stop and leave the location. Witness 1 then left and came back about 5 minutes later to find the defendant was still charging the phone. Witness one asked the defendant to leave again, and the defendant did. The defendant then came back a short time later and began to behave as if he wanted to fight the reportee. Witness observed the defendant throw rocks at the window, and while the officer was gathering the statement, the reportee observed the defendant to be walking by. Officer detained the defendant, and the reportee was able to ID the defendant. He has no criminal history.
I'm removing this requirement to surrender.
Yeah, but why did he have to break the pizza shop windows? Can't he go find like a mattress place or something?
His passport, remain in Harris County and its contiguous counties. It's not standard conditions. Is this something that can resolve today, or how old is it?
Your Honor, it's not that old at all. There are two things to bring to the court's attention. I do have an application for your.
Oh, the emerging adult docket.
Yes,
Okay.
the issue is he's semi-homeless, so I'm trying to work that
There's
out.
some resources.
So the emerging adult docket, I think she handles, and I think that it's something she's trying really hard. So she's really pleased that he's going there.
For housing.
Okay, perfect.
In the program.
I'm in contact with his family. I need one more setting.
Okay.
Get that.
Perfect.
You have to
Thank you.
excuse.
Yes.
Thank you.
Sammy, can you write his name down? Good morning.
I think this next one, I think it's this one. It might be the one after this. I don't know. But we're not going to see the defendant, I don't think. But it's a big deal.
How are y'all doing? Yes. I was trying to find a court reporter. Today's Miss Lee's.
I'm trying my hardest to get.
Okay, today's Miss Lee's birthday. So
Short today.
she's out.
Maybe for today, we probably don't need to be on.
You don't think so?
No, I don't think so.
Okay. What is your name, ma'am?
You set me up, I'll say your honor.
I'm
Mr. Wolf, nice to see you again.
Let's support people.
Okay, let me get a legal pad. Sammy, can you grab me a legal pad? Let me see that. Yeah.
Your Honor, I have courtesy brought courtesy copies of the opinion.
Yeah, I read it already.
Right.
I have one right here. Oh, but I don't have this one. Okay, thank you. Okay, thank you. Okay, well, tell me what's going on besides the obvious.
I think probably the biggest next procedural step is probably going to be waiting on the mandate to issue. Because we can't, he cannot be resentenced to life until the mandate issues. But then once that occurs, our office really doesn't have, our office will not be reseeking death, which then only leaves the one other option of his sentence being, I don't know, commutation is not really the right word, but the only other option then is for him to use,
What did you say?
Reformation of the sentence to life. And then at that point, it's just a matter of how we do it. And then I leave that to the administrators. Sort of discussion and suggestion.
Right, so, Your Honor, I think what we would propose is, so there is, as Mr. Smith indicated, it's really just, you don't have to take sentence of life and as the one, legal sentence. And what we would propose is that, so Mr. Jordan has any number of ongoing health issues that he not be bench warranted back to Harris County.
So, sounds weird to me, but I think that he had the death penalty. And because he has all these health issues, he no longer has the death penalty?
Well, waive his appearance. And he would be, his sentence would be reformed to the only legal sentence available, which is life in prison. And then the judgment and sentence paperwork would be sent back to DPS. Yeah. He's currently in the Estella unit hospital wing, and with a life sentence,
I mean, he's in hospice, so.
As opposed to a death sentence, even though he hasn't been at risk of execution in the last 30-something years, because he was,
He got the death penalty 30 years ago. I don't understand, guys.
deemed incompetent to be executed in the late 80s. It actually would open up, like, a lot of different, kind of medical and supportive care possibilities because, just because of a TCJ classification policies. And so we had a case in a very similar posture for which we did basically the same thing that we're proposing here a couple of years ago with Syed Rabbani. And
A couple years ago, what did you say?
we had a case in a very similar, presenting the same issue where he was actually in the joining cell to Mr. Jordan and in the cell unit. The client's name was Syed Rabbani. He was granted plenary relief 2 or 3 years ago. And we did the same thing that we're proposing today in a different courtroom. And then because he was no longer under death sentence, he's actually in hospice and at the Carroll Young unit in Galveston, I believe. And which is something that PDCJ medical staff had previously recommended, but were unable to accomplish because of classification procedures, basically.
And Judge, Mr. Wolf and I did that one together, and there was one a couple of years before that as well, that the same thing happened by the same procedure.
Okay. So we wait for the mandate.
Right.
And then y'all will come back?
Yes, and so we can, we could schedule it out now, or we can wait for the mandate to issue, but I think it would be really important on behalf of Mr. Jordan, and it is the court staff not issue any bench warrants.
Well, we recall the bench warrant. We were not aware of his medical status.
Okay.
And so we're not bringing him back.
Okay, wonderful, right, and just didn't want to make sure that there wasn't gonna be anything that, just done automatically.
Yeah, Andrew came by yesterday and told us we were being.
Yeah, whenever Joey is so efficient, and then whenever he said, I was like, oh, no. Ben, I was like,
please stop.
I was like, Ben does not want that.
It was my fault. So, okay. Do we know when the mandate is supposed to come now?
Like 20 days.
Yeah, so I think probably.
By the end of the month.
Yeah.
Okay, why don't we get a date in May?
Okay.
And y'all can, I know you're in Austin, y'all can just work together to figure out what works for your schedules.
Perfect.
Okay, thank y'all.
Thank you, Your Honor.
Wayne?
Just how are you?
Good, how are you doing?
Okay. Should have a new case in your docket today. As Jafon Hamilton, it was a transfer from the court. And basically.
Transfer from where?
It was from, gosh, where were we?
It's from the 185th judge. He's a co-defendant for Denham Hines, Keisha Bailey, and Darius Weatherford.
And let me give you a quick update of kind of where we are, where we're headed, what I think we need to do today. My client is 17, because he was on a juvenile probation, and he picked up a tampering case. That tampering case, while on bond, not an ankle monitor for that tampering case, he then picked up 2 new aggravated robberies, and then they filed engaging in organized criminal activity for each of those aggravated robberies. One of the robberies ended up also involving a car theft, and that's where you get your UMV from. So basically, it's 3 total events, and then there are like 7 cases filed based on those 3 events.
I'm still missing one. It's robbery by threat.
That's the other robbery. There's 2 robberies. One was the aggravated robbery. The other one was a robbery where he's not the gunman. The gunman is a co-defendant.
They're vape stores, Judge.
Both were vape stores.
Okay.
And I think the UMV came out of the robbery by threat. Right. Client is, I think he just turned 18. Let me tell you kind of where we're headed, Judge. We were actually on the way in that court. I'd already talked to the court about it on appointing a psychiatrist to assist me. This is likely going to end up being a PSI, Your Honor, but there is definitely some mental health issues that are plaguing this young man, which is why he's having all this trouble. The other thing too is that you can probably imagine at the age of 17, wearing an ankle monitor going on this crime spree, there's some developmental disabilities as well. And so basically all that information I think would be relevant to you on a PSI, Judge. That's what I believe, absolutely this is heading. I don't believe we're heading towards trial. So we just need a little more time to get all this squared away. I will have a motion for you shortly. I hadn't done it in the last court. Since I heard it was going to be transferred, I figured I'd wait to talk about it.
Yeah, and you can just approach off docket.
I'll do that.
I think we're gonna ask, we're gonna let book discovery on all the cases.
I think we've got it, Judge. I don't think there's anything outstanding. There has been a couple things trickling in here and there, but it's nothing I think that I've come across that I seem to be missing.
Okay, thank you for the update. So we can set this for, and the state has offered to come into the court on the PSI.
Yes, Judge. We have offered 25 years on one of the engagings, or a PSI, and
The only holdup for us doing that, Your Honor, would be
mitigation.
Just to get the mitigation together.
Okay.
And if anything comes up, which I'm quite confident it won't, that changes our opinion, I'll let the court know immediately. But I would bet quite a bit of money that this is just going to be a PSI.
Probably better that you didn't hear everything he said, V, because it's very sad. This 17-year-old, he's 18 now, just so many criminal charges. Oh my gosh.
Judge, just need time to mitigation together.
Okay, sounds good. Thank you.
And Judge, just real quick, I think we're gonna need bond conditions. I would just ask to mirror.
He has $1 million bond on 3 of the cases.
My client is impoverished. He was never going to make it anyway. I think that is the conditions. We have no objections to making equal to code across the board.
On the tampering, there's no bond set.
Yes, bond, Judge.
Okay.
And quite frankly, this is an impoverished family. There'll be no bond, and whatever you decide, Judge, will be fine.
The tampering is about what? What's the PC?
So in that case,
It doesn't matter, Judge. He has $3 million of bonds already. Just pick a number.
basically what happened is that he was involved with a group that went into a gas station that's across the street from where he lives. And while some people were trying to steal things, he was trying to hide things that they were trying to steal. I think that's what the allegation is. There is a gun involved. Like he tried to hide a gun that one of them had before the police got there, but it's like in the store. Like he was trying to hide it in the store. And I think that tampering is that's where that comes from. And that's when he was put on an ankle monitor because he was on a juvenile deferred for aggravated robbery when he picked that up. And then after that is when he went on the next two.
I'll set the bond. Okay. I'll set the bond at $100,000 on the tampering.
Okay.
And we'll reset so you can get your mitigation together and then file your AK motion.
Oh, that poor kid. Thank you. I just think about my son, who's slightly older than that, having $3 million worth of bonds and all these charges. That would suck. All right, we're gonna end the stream on Judge Fish.
Good morning. This is 64D01-1902CC.
I think he has a civil case today, I think, if I remember correctly.
E1268 Portfolio Recovery Associates LLC versus Christine O'Brien. We're set today for what appears to be a request from Ms. O'Brien related to the garnishment in the case. And what I think is that there was a hearing for proceeding supplemental. Perhaps Ms. O'Brien failed to appear for that. Or actually, it looks like the garnishee defendant failed to participate in responding to interrogatories. Do you have positive interrogatories on this case, counsel? Let me go through and announce who's in the courtroom. Please introduce yourself, sir, for the record.
Sure. My name is Trevor Lamb.
Okay. And you're with Portfolio Recovery?
With Blitton Gaines, but we represent Portfolio.
Okay, fantastic. And you're Christine O'Brien? Okay, can you take that microphone and point it towards you? Perfect. Thank you. So do you have positive interrogatories on this case?
Yes. From what I was been told before coming here, I was told that we had just received positive interrogatories.
Are they filed?
When I was been told, it looks like we had, I don't know, I think they might have sent them to us. I don't know for certain, because I think they had only sent it recently.
Okay.
So I don't know if they've filed it with the court or just sent it to us and then.
Okay.
Yeah, I apologize for the uncertainty, at least on that front. But
No, so there's a couple things going on. One is that the Odyssey case filing system has had some difficulty over the last few weeks. So we got a huge dump of information into the filing system that my staff has been working with. So if it has come in over the last couple hours or last couple days, it just might not have been docketed quite yet. So anyway, and then Ms. O'Brien, you had requested me take a look at the garnishment proceeding here. What's your perspective?
Yes, Your Honor. So this is the first time that I got the letter because I came up here that day and wrote the letter because my employer sent it via email. And they sent it to that address that was on file, but that I haven't lived at that address for over 23 years, so I had no idea that they were doing this. So that's when I came up here and she said I could write a letter to the judge so I can try to work this out without the wage garnishment. And I don't even know what this is for. I tried calling them several times. I was on hold for several hours and then hung up on because no one was available. So I'm not even sure what this old garnishment, this old balance is from. It just says portfolio recovery. It doesn't tell me where it came from or where the original company was from. I tried making several attempts to contact them and I couldn't get a hold of anybody.
Okay. Well,
actually, now that I think about it, a cracker with a little bit of Vegemite and a sardine would probably be delicious.
It looks to me like that you were given service of process of a lawsuit at 7 Hebron, Indiana, and that service was made back on February 14th, 2019 at 6:17 in the morning. And thereafter, the creditor obtained a default judgment on you, and that there was an order granting default judgment from this court dated March 21st, 2019. And then subsequently, as they do, the plaintiff filed a motion for proceeding supplemental to execution on July 15th, 2021, and they have been attempting to collect their judgment since that time. So what are you asking the court to do, ma'am?
That's what I said. I didn't get any of that stuff, whatever that stuff was, mailed or certified mail, any of that stuff. So I don't, who's the original creditor? What, it doesn't say, what is that from exactly? Where's this law? What is the amount for the lawsuit? Who is it from?
I would suggest that the original creditor doesn't particularly matter to the court, but there was a bill of sale from Barclays.
How often do you think Judge Fish gets his hair cut?
From June 1st of 2018. A Barclay card with the, well, I don't even know that they put last four of account numbers on it anymore. But at the time of the lawsuit, you had, and this was charged off back on June 1st, 2017, with a balance of $850.45.
Okay, so that's a credit card. Thank you for clarifying that.
I just can't find out anything more specific about the credit card.
I love seafood. I had shrimp chow mein for dinner.
But maybe that's all you need to know. Oh, here it is. The last four is 5729. But I'm assuming it's not one you would use anymore.
Sorry, prawn.
Anything else,
chow
ma'am?
mein.
What are you asking the court to do?
I'm asking the court to work out with the company so I cannot do the wage garnishment. I've had financial hardship for a long time, and I'm trying to get back on my feet, and I haven't able to do that.
Okay, please raise your hand to be sworn. You swear or affirm under penalty of perjury to tell the whole truth and nothing but the truth?
Yes.
Okay, thank you. And ma'am, what do you do for a living?
I'm a receptionist.
And where are you a receptionist?
It's owned by VetCor.
Say again?
It's VetCor.
Is it like veterans or a veterinarian?
No, it's a veterinarian clinic.
Okay.
Yes.
And how much do you earn as a receptionist?
I make $16 an hour and I get about 36 hours a week.
Okay. Any other forms of income?
No.
How much is your usual take home in your paycheck?
It's about $8.95.
You have a paycheck with you?
No, that's all electronic. Couldn't bring my phone. I couldn't print copies.
Oh, it looked like you were referencing something in your file.
Oh, I have all my like rent and all that stuff, bills.
No paycheck though?
No, it's all electronic.
What are the withdrawals taken from your paycheck pre-tax?
Insurance is about $90 every 2 weeks.
Anything else?
No,
Any contributions to savings accounts or retirement accounts?
just the $90 every 2 weeks.
Okay. Do you live with anyone?
I rent.
Do you rent with anyone?
I rent with there's another renter. Yes.
Okay. And how much is your share of the rent?
Without the utilities or just the plain rent?
The rent payment is a good place to start.
It's $650 per month.
And that's your portion of it?
That's correct.
And then do you also contribute to some utilities?
Utilities, there's ComEd, NICOR, water, sewer, and gas.
Is that combined then?
No, they're all three separate.
And what are the numbers there?
ComEd's about 100, NICOR gas is about 120, water, sewer, and garbage pickup is about 125.
And are those all,
Those are half.
is that your share?
That's my share, yes.
Okay. What else are you spending money on then? You have a car?
I have car insurance and a car payment, that's $240.
Your car insurance is $240 or the car payment?
The car insurance and the car payment is $240.
So that's combined?
That's combined.
What kind of car is it?
It's a 2011 Lexus 250.
Do you owe money on it then?
Yes.
How much do you owe?
About 3,500, I believe.
How many miles are on it?
157.
Okay. Any other expenses for the household?
Not for the rent and that kind of stuff, no. The other stuff's my stuff.
Okay. How much do you spend on food?
Food is about 400.
And do you have any kids?
No kids.
Is your current counsel any questions? Would you like to follow up with any questions?
Not right now, Your Honor.
Okay. What are you asking for related to a hardship, ma'am?
I had a really bad accident recently.
No. What's your ask?
So the hardship is
Do you want to pay towards this debt?
I can pay $50 a month is what I'm getting from all my medical and rent and other bills that I have. I don't have very much money left over after that.
I don't think I can go that low.
I mean, I get minimum wage. I have limited hours. I just literally went back to work 2 months ago. I was off work for 4 months.
Want to take 50 a month, counsel?
I don't know if that would work because it's Bren. Like, that's not a name. I think if you're going to harass someone, don't you have, like, how much personal damage could you do to his life if you called him an idiot when you're actually just calling Bren an idiot? I mean, I don't think it translates. It wouldn't affect him personally in his life, would it? Just like you, someone calling great granny an idiot. I don't think you could sue for that because your name isn't great granny, right, Violet?
What was the amount again?
50? A little light. I think I can go to 10%, right?
I think that should be doable.
What should be?
The 50 a month.
He agreed to 50 a month.
Okay.
I use the
Yeah, I mean,
phrase
that is
flea. Some people are like fleas. I can just flick them. You use mosquito.
That's a gift, man.
Prove it.
The lowest I can go
Send me
is
your social security number.
or 90.
You don't have social security number.
$89.50 per paycheck for you is the lowest I could go.
Well, that's what I'm asking, for the court to work with them instead of doing the wage garnishment.
Well, I don't know if they're going to do that.
I mean, every job I've had where I've had wage.
How entitled are you? He just dropped that number from $180 to $50 a month, and you're still complaining.
Garnishments, I've been let go. And you can go back as far as my other jobs. They don't, that is fraud upon. And I can sign a document where I can make monthly payments, $50 a month.
You want to do an agreed post-judgment payment arrangement for 50?
Yeah.
Do you have some handy for her?
Fine, just send me your credit card number and that 3-digit code on the back. Don't forget.
All right, that's what I'll do then. I'll show that the parties reached an agreement on the open record and that Ms. O'Brien will be permitted to pay $50 a month through an agreed.
Try to make sure your balance is $700,000.11 first, though.
Payment order. I'll look for that to be tendered within the next, say, 10 days. And then if she fails to maintain the agreement, counsel will be permitted to ask for a final order and garnishment on the paycheck. And I would advise you, Ms. O'Brien, that if you feel like you were fired because somebody garnished your wages, you should talk to a lawyer about that. Because I know you live in Illinois, but I still feel like that's probably some sort of a problem for that employer. But. Okay, so I can do an entry from today?
Yeah, and then I'll go ahead and once we get done, I'm just gonna hand over on the little sheet of paper. I'm just gonna hand in my contact info. Just that way, there's a contact point for her.
Thank you, Mr. Lamb. And she can work directly with you.
Yeah.
To get this done.
Yeah, probably just since I'm the one that appeared, probably be easiest. Just that way, I'll just give her my email and cell phone number.
It would take me a couple months to make $99.
Just to make sure I have for my notes, you said the pay word, do you want just like an agreed order or since there's a judgment already, just like a letter filed with the court with the notice?
Seriously though, this lawyer better hope that his client never watches my stream because this lawyer just rolled over.
So what I see on occasion is an agreed payment plan.
Okay.
And it avoids garnishment, but it does contain that same language that the garnishment can be triggered by the failure to pay.
All right.
Right? I would think your firm has something like that already.
I'll check. As I know, I'll check with one of the other attorneys that and see if there's a template on file.
Okay. Speaking of Patreon, I got 2 of the videos up free. Like you don't have to pay to watch them. I got 2 more. I'm hoping they didn't stream last night because I was busy and I didn't get a chance. I was live streaming. My live stream cut into my Australian court watching time. So hopefully they didn't stream last night. They haven't streamed it all this week, so maybe they didn't. But I'll get more as soon as they start streaming again.
As for the amount, 10 days should be okay in terms to get that filed.
All right, sir. I'll leave it at 10 days then in my entry from today, and we'll calendar the file up for that, okay?
All right.
And we're adjourned. Thank you, folks.
Thank you.
He came on, but then he put on.
And Granny, I think it was Granny, right? V, you said Judge Fish was going to end with a bang. Oh, it sure is, all right. This guy right here. I left the beginning in. Nothing happens for a minute or two. We're just watching him for a minute or two before it comes on.
Then he came and put this
And
on.
I was going to say that.
Then it popped up on the side, said use your control to respond. What time is it? 12:30? Mm-hmm. What's it say on that? Got no time. I got Supreme Court, one courtroom, then it got the judge's face. And it moved what you had on that, what had on that first. It said respond with your remote. I guess he tapped in. I guess they probably pulled back out.
Call to the website.
Here, garnishment, that's 1J3K after trade and split up super.
There, 7, we're going through a trash. Right there, you can see it right there. No, I know that one dead inmate workplace.
Morning, everybody.
Good morning.
Good morning. This is 46D02-2007 CT1144 Kevin L. Martin versus, the case is styled as Sergeant Chilling, but the defendant's name is Daniel Childers. We have Mr. Martin in court in person from the Department of Correction, and I have Alan, is it Coos or Cuss?
Kuss, Your Honor.
Kuss in court on Zoom representing the defendant. I received the motion for summary judgment back on February the 11th of 2026. I received the defendant's matters and response about March 13th, 2026. And then I have a reply from the defendant. I'm sorry, I got plaintiff's response, and now I have the defendant's reply from March 27th of 2026, or movant's reply. So it appears to be fully briefed. Are you prepared to argue, Mr.?
JK, you're going to have to breathe through this. This is going to be very hard on you. Out of all the clips I play, this one is going to be particularly harsh on you. You actually might just want to go make a sandwich or something, because this might be too much.
Who's?
I can, Your Honor. Yes.
Okay, and are you prepared, Mr. Martin?
Yes, sir.
Okay, thank you. Mr. Cruz, proceed with your argument, sir.
Thank you, Your Honor. First, let me apologize again to the court. I completely missed this hearing and that is why I'm dressed and late, and that is my fault, and I apologize for the court and frankly to the plaintiff as
We are glad you're dressed. Thank you, sir.
well. Having said that, the defendant's motion is basically brought on two different grounds. The first one is the summary judgment ground of failure to exhaust his administrative remedies, which required plaintiff to file appropriate grievances at the appropriate intervals, appeal them all the way through. And as shown in our brief and in our motion, that did not happen. And then the second ground for summary judgment in this case is that plaintiff blew the statute of limitations when it came to filing this matter because the alleged incident happened in March of 2020, which meant that the statute of limitations ran or expired in March of 2022. And as the Court of Appeals previously found in the prior appeal for this matter, plaintiff...
He is not a delicate flower. He just knows the law better than any of us. And this guy in this cage with the soundproof walls, except with the cage in front of it, which sound clearly easily travels through, is about to go on a spiel that no one's going to be able to understand.
Not fulfill all of the filing requirements until at the very earliest February of 2023. And then in reality, they weren't really actually satisfied until January of 2025 when the payment was officially made towards this particular case. Unfortunately for plaintiff, the case law is very clear that in order to fully initiate a claim, you have to file the complaint, the summons, and pay the filing fee. Because the filing fee was not paid in a timely manner, the case did not timely commence, and therefore it's barred by the statute of limitations. So whether the court wishes to decide this on statute of limitations grounds or on the exhaustion ground, the result remains the same in that summary judgment should be granted on behalf of the defendant. Thank you.
Thank you, sir. Mr. Martin?
Okay. Well, I would ask you to take jurisdiction notice on Indiana Evidence Rule 201 for these reasons right here. I filed the complaint on time, which the defendant admitted in his motion to a summary judge. Now, once the court get it, the court must assess the complaint by the Indiana Statute 3458(1)(2) that requests the trial court to assess the complaint filed by Alpha as soon as the complaint is received. That's the screening statute. So if it's not screened, then the trial court abuses discretion. But also, let me direct your attention to Indiana Code 3337.33D. The state in part, if the court denied the application to waive the fee, the court should give a right notice to the offense that your case will be dismissed if the partial fees is not paid within 45 days after the day of the order, which that thing never happened. That's another abuse of discretion, but also violate the Indiana Constitution. Article 1, Section 12, available of the court, the delay. I had nothing to do with the delay. I filed the complaint in time. I filed all the documents in time. And that's the reason why I asked for the hearing, but I didn't get your notice until the hearing, until this Thursday that's passed. My thing was trying to put T. Welch, I'm saying his name, the other defendant that I had in the complaint that they removed from the complaint because they said it ain't no constitution right. He didn't do nothing wrong because he didn't e-file. I came here, the same facility I'm at now, to go to trial in Terre Haute on another case, Kevin Moore versus Lieutenant Nicholson, and the incident took place. So when I come here, I have to get a grievance to them to e-file. If he don't e-file, it's out of my discretion. You could I would like for you to take a look at the case I call Ashley Hill versus United States, when the Seventh Circuit said all you have to do is submit the grievance. If they don't accept the grievance, you don't have to play guessing games for no one to accept the grievance. But the only way I was going to be able to develop a record today for the courts of appeal to be able to review and see what I'm saying is only way if I would have put the grievance specialist on the stand that gave him affidavit to show she was not the grievance specialist in 2020. Also, the caseworker who you put the grievance in their hand, who take them to his mailbox and put them in his mailbox. But also, I created a general issue of material fact. I attached the same grievance that I attached when I went to the courts of appeal, and they overturned it. So the defendants weighed their right, and I'm gonna tell you why they weighed their right, because first of all, for any case proceed, the exhaustive issue is the first issue that's supposed to be handled. And I'd like the defendant to respond for that. The attorney general that represents, we ain't developing no record here, because the only way we develop a record is like the federal court do. We put the defendants on the stand and be able to show that at any time attorney general will represent a defendant, the first issue, did he exhaust their state remedies? Which when they came to T. Welch, he had told them, and that's the reason why they didn't go for it. They tried to go for, I failed to state a claim on which relief could be granted. And they had the opportunity to raise the exhaust, and Chief Welch would have told me, yes, he presented, but I didn't e-file it because he felt it wasn't his job. That he felt it was my job when I get back to the facility, because I was only here for court reasons to address the issue. So once I submitted to him, he didn't send it back within 10 days by the policy. And the cases that I used to you, that I cited to you, in there say that if they fail to follow their own procedures, he didn't follow his own procedures. I would say he should have rejected. Then I had 5 days to resubmit it, which he never did. None of that. And that's the reason why I put West in there. Say he refused to e-file it to Westfield. He refused, and at that time the COVID broke out. So when the COVID broke out, I had stayed here for probably about.
Judge, it was the COVID. That's why. I figured it out, guys.
70 to 90 days before I went back. So it was on him to e-file it so the issue could be addressed with the grievance specialist there, and they could have holded the evidence. So when he failed to do that, there's no way. Then he said, I failed to commission the lawsuit. I filed the lawsuit. If the lawsuit, I filed a lawsuit in the court, and all the documents was attached. And then Ms. White, the caseworker at Westfield, could verify that. My thing was the hearing today is like the federal court. You be able to put the defendants on the stand and be able to develop the record. Because this is word against my word. It's a conflict. I presented the same grievance that I used in the courts of appeal. That's why they removed T. West, because they said he can't be held liable for, because he ain't violate no constitution for not e-filing a grievance. In the same way.
Actually, Kelly, we haven't heard the hurricane being used as an excuse in a while. We need another case where the hurricane was the problem.
You seen the complaint when I asked you to review the complaint. What he's saying that I failed to commission. No, the court abused their discretion because the court failed to present me an order telling me that I had 45 days. They failed to screen it. They failed to screen the complaint, and he just said we dismissed it because he failed to pay the filing fee. It don't follow me. Then if you rule it, it's an arbitrary decision, because simple fact is this. And he know, I want him to answer this. He know anytime in the federal court, he using federal law. And that's the reason why I present that. I say it's for a jury to decide that I exhaust the state remedy. And that means that I have a chance to bring Welch in. I've ready to bring, since I couldn't get him here today and develop a record. That's what the hearing for, is develop a record. I didn't get the hearing until the hearing gonna be until Thursday. If I would have got in time, would have sent a subpoena that I wanted the grievance specialist to be here, because she lying, which I got a grievance that I filed already, that she can't investigate, the warden here investigating the issue. That she lying because she was not the grievance specialist back then. She gave an affidavit under oath, and she lied under oath, and he violated any other. And I'm here working on the complaint against him now. He violated any kind of conduct, professional conduct 3A. A lawyer should not knowingly offer evidence that a lawyer known to be false. And he introduced it to another jurisdiction office, which is the judge here, Fisher. He knew it was false. She was not the grievance specialist back then in 2020. So I'm not getting a right to be heard here under my 14th Amendment rights. It's nowhere in the world I'm being heard, because the only way I'm being heard if I'm putting these individuals on the stand and be able to direct their attention to evidence for her to show, just like I give you a request. I send her a request and I say, was you the grievance specialist in 2020? She said, no, she's trying to tell me, oh, I don't know. I don't know what position Lanford had. You know, Lanford was the caseworker. So, you know, and I asked for you to give.
Okay. If you're Judge Fish, you have to figure this out, right? He does. Don't worry. He's excellent. He's great. But if I was the judge, I would have stopped him a couple times, because I have absolutely no idea what he's saying. None.
The Indiana Rule of 52, a facts and conclusion, laying out a fact, and that would give the courts of appeal a better chance to review why you feel that I didn't create a genuine issue of fact, and it also is a conflict. You can't take my word, because the grievance specialist was not the grievance specialist back then. So to give an affidavit on something she don't have no knowledge of, that's what, when you give an affidavit to something you got knowledge of. She was not the grievance specialist back then, so she would have no knowledge. When you give an affidavit.
Sir, I give information on something I have no knowledge of every single day, multiple times.
They say I have the knowledge of something. She ain't got no knowledge. She wasn't the grievance specialist back then. So I wasn't able to put them on here, so I would ask for you, and I feel it's a due process, right, because it's to a defense. I would ask you today for a continue where I could be able to subpoena them on the Indiana ruling 45 AE for a hearing. This is a hearing. I would like to put her on the stand and put the Lanford, the caseworker at that time when I came back to go to court, where I put it in her hand, and she said I put it in his mailbox. That is reliable here to prove to you that I exhaust my state remedies.
Hey,
and
Mr. Martin.
Yeah.
You asked me for a continuance of today's hearing?
Yeah, and because that's a due process right if it's to my defense, because I would like to put the grievance specialist who gave him affidavit, and I would like to put the caseworker who hand I put the grievance in when I came back to go to court in 2020.
Right, but
and that's reliable to my defense, because that would show I didn't get yours until Thursday. I got
Mr. Martin. Martin. You asked me for a continuance because you'd like to call witnesses.
Right.
This is a motion for summary judgment hearing where there are no witnesses. Any witness statements you would want to tender to the court, you would have had to have done before the deadline ended for your response and for you to tender affidavits from these people. That's how the summary judgment process works. So I'll deny the motion to continue.
Okay, they ain't gonna give us no affidavit. If I come to her to get an affidavit, she gonna say the court have to order us to give an affidavit. They ain't gonna, if I come to her and say, I want an affidavit to the caseworker to show that I put it in your hand, she gonna say, we cannot do that. She gonna say the court will have to give us an order for us to do that. But in the federal court, if a hearing go on about exhaust, you have an opportunity to bring them on the stand and put them on the stand. That the federal court going to appoint you an attorney. It's going to be in here. You're going to be able to put them on the stand and ask them and develop a record. That's the only way to develop a record. We ain't developing a record. She's saying I didn't exhaust the remedy, but she wanted the grievance specialist back then.
Mr. Martin, sir, this is not a federal court.
I know that, but I'm saying we're using federal case sites. He used federal case sites saying I didn't exhaust my statement. I use a federal case site to say anytime it's the 8th Amendment right.
Mr. Martin,
if a conflict come about.
Mr. Martin, summary judgment works the same way in federal court. You'd have had to have supplied affidavits.
No. When it comes to a exhaust issue, in the federal court, if it comes to exhaust issue, if I'm saying that I presented the grievance, and they saying that I didn't present the grievance, the federal court already know that you can't, that they ain't gonna give us no affidavit. That's a fact. The federal court, if you look Ashley Hill versus United States, they know that they ain't gonna give us no affidavit. They ain't gonna give no inmate no affidavit. They gonna say the court have to give an order. So, I gave an affidavit saying I submitted.
Look, any moment he could have a Barry Mason moment. V, you don't know?
I gave you an affidavit.
Mr. Martin.
Saying that I submitted the affidavit. But
Mr. Martin.
Yeah.
So I don't have a lot of more time to handle this case, but what you're telling me is that you believe there's an issue of fact for the jury about whether or not you met the administrative requirements and that you'd like for me to deny summary judgment. Does that sum it up, sir?
Yeah, yes.
Okay. Is there anything else you'd like to add briefly?
Yes. And okay, he said that I didn't exhaust. So if you read the summary, Judge, you'll see he admitted, and that's his admission. He admitted himself that I filed it in time. And it was a stagulated because due to the fact of the disagreement that me and the judge were having in a Newport court before you got it. The agreement, the conflict that me and the judge was having with me filing complaints on the judge. So it messed around. The judges kept going to other judges, and it kept starting on. Then it came to you. When it came to you, that's me and you made the ruling on granted they motion to miss, but then that's when they should have filed a exhaust. I'm gonna ask you this question, you're a judge. I'm gonna tell you if I'm right or wrong. Anytime I want him to answer this, I'm gonna make this real short, I'm in it right here. Anytime a case go, the first issue you deal with is the exhaust. They waited, they should have filed an exhaust when they filed a motion for a dismiss, when they said I fell at the state of claim, and I went to the courts of appeal, and the courts of appeal reversed and said I stated an Eighth Amendment claim. That's when they should have filed the exhaust. That's when the exhaust before you do a discovery, exhaust get handled. You cannot go to court and do no discovery stages. The exhaust get handled before that. He know that. He's an attorney. He know that. Before we started the discovery, Indiana rule 26, 33, 34, 36.
This attorney has no idea what he knows anymore. He's trying to figure out what's going on.
We don't do none of that until the exhaust issue is completed.
Until the what? Can you say it again?
To the exhaust issue, that means the grievance. That means that the grievance exhaust. They call it exhaust. I mean that I exhaust my state remedies.
You're using the word exhaust.
Right. I'm probably saying it wrong, but it's exhaust. EX.
The other thing, Mr. Martin, let me just clarify. The other thing I think you're arguing is that there's a question of law about whether the time told as a result of the screening not being done as quickly and then it having to go up to the appellate court. Is that what I'm hearing?
Yeah, that too, but also the exhaust. He know what I'm saying about the exhaust. He attorney. Before any lawsuit proceed under 1983, the first issue they deal with is the EXHAUST. First, they make sure that you attempted to file a grievance and exhaust your remedies. Okay, that's for the discovery procedures even proceed. And he know that before he even proceed. So
I understand, Mr. Martin. What I don't have is any more time for this. So, Mr. Coos, did you want to reply at all in a few sentences, please?
Your Honor, everything that the plaintiff is just talking about relates solely to that issue of exhaustion, which admittedly is done differently or in a slightly different order in the federal system, which is why I think plaintiff is a little confused or used to one particular way. That being said, even if you ignore any of the exhaustion issues, which we do not think the court should do, but even if you were to do that, it still doesn't change the fact that the Court of Appeals specifically found that plaintiff did not commence this case until February 16th, 2023, which is beyond the statute of limitations for when the case needed to be filed and commenced. And Indiana case law is pretty black and white. It's pretty brutal in some respects in that you have to do all three filings in order to have a civil action being commenced, and substantial compliance is not applicable. We mentioned this in our brief. It's the Hortonberry versus Palmer case, 992 Northeastern 2nd, 921. And that's out of the Indiana Court of Appeals in 2013. But fundamentally, Your Honor, even if there is some material issue of fact on exhaustion, there isn't anywhere near that on the statute of limitations grounds. And on either ground, statute of limitations or exhaustion, summary judgment is warranted.
Okay, well, thank you both for your presentations here this morning. I'm happy to take the case under advisement and get a ruling out within the appropriate time. Thank you both.
Thank you, Your Honor.
Yeah.
I mean, how could he rule on that? It was a bunch of Words. But it's over now. Thank you, Judge Fish. All right, guys. Whew. The last 3 streams have been rough. Once they took down my my Australian cases, I had to scramble, but we made it. We made it through the last 3 streams. Thank you so much for coming. Appreciate it. All right, I will see you all in another day. Behave today. Be nice to each other. Everybody's having a shitty week. So, be nice to each other. And I will see you tomorrow. Bye, guys. Thank you.
Well, I thought I'd write a happy song. I found a chat room where I belong. You don't know how much it means to me. With such a groove, I'm less lonely. Oh, Kathy's the creator, she's leading the way. At court vibes, we laugh and we stay. Her smile shines bright, she's got that grace, come join the fun. It's a welcome and play. I can count on distraction from my pain, 'cause this creator takes you there and back again. Kathy is the heart here, always in stride. Her work is hard, but her joy she can't hide. Oh, Kathy's the creator, she's leading the way. At court vibes, we laugh and we stay. Her style is classy, she's always top shelf. Don't take my word, come and see for yourself. Her cases are new with a twist or two. I really like them, I believe you will too. A little lifeline passed along in rhyme. Why don't you join us? It's a guaranteed good time. Oh, Kathy's the creator, she's leading the way. At court vibes, we laugh and we stay. Her smile shines bright, she's got that grace, come join the fun. It's a welcoming place. And so in conclusion, I'll wrap up this song. I hope I didn't miss anything that would be wrong. Hope I see you around. Don't stay on the shelf, join in the laughter. Come and see